Yes. Okay, let's start it, Megan.
Okay. Hi, everybody. Nice to meet you. So I'm going to try to make this as entertaining as possible.
Yeah.
And I will take questions at the end. As you can see, there's a little bit about myself, but I'm going to share my presentation. Hopefully you guys don't hear any background noise.
Yeah. I will stop the sharing at my end and you can.
Continue. Okay.
Yes.
Let me see if I got it.
Oh, actually.
Did it work?
Yes, it works.
Yay. Okay, hopefully you guys can see it. Okay.
Yeah.
So today I want to cover why you need an estate plan. Many of you might already have an estate plan in place, or you may have a will, or you might have discussed it with your family, but I want to kind of cover why you would want to move forward and do a comprehensive estate plan and what that is. So a little bit about myself. So I'm an attorney. I'm domiciled here in California, but if you're in other states, we can still help you. And I'm also a registered investment advisor. So I've spent my time really focused on helping entrepreneurs, business owners, and families do financial and estate planning. So that's mainly what I do. I don't do any litigation. So a lot of attorneys, you think, go to court and they're like fighting and, back and forth. I don't do that. I just do the planning. And with the planning, the hope is that we are producing outcomes where your family doesn't end up in court if something happens to you. And that can be whether you pass away or you become incapacitated during your lifetime. So comprehensive planning kind of involves multiple people, right? So if we start to work on an estate plan, you have to go over all of your assets and all the family members and your wishes. So when we do that, we have multiple people involved, right? We have your financial advisor, if you have one, the estate planning attorney, insurance agent, if you guys have insurance, maybe a spiritual advisor, pastor, rabbi, depending on if that's involved in your family, and then your accountant and other key people that help with your decisions. That could include, key employees at your company or business partners, other people that are involved in some of your important decisions. So why do you need an estate plan? I would like to go over tonight, and I believe I'll go for about, I would say 30 minutes. I have a video I'd like to show you guys to keep this entertaining. So if it plays, we'll go over that too. But I'm trying to explain tonight how you avoid probate. And probate is the court process of your family getting your assets in the event that you were to pass away or become incapacitated, still alive, but can't function. Next one is maintaining control of your assets. Explain why an estate plan can help you maintain control of your assets. Also try to explain to you how you transfer assets quickly. I'm going to go over privacy issues, how when you do an estate plan, we're trying to avoid court supervision over any asset transfers in the event, again, two instances, when you pass away or become incapacitated during your lifetime. The next thing we're going to go over is protection from incapacity, or a form of incapacity where you can still be in control of your assets. I'm also trying to avoid family disputes. We're trying to transfer wealth to the next generation. We're also trying to do tax planning. We want everyone to have a peace of mind, and then also liability protection, okay? So tonight I can't go over all the details of everything, but I can at least give you a general overview of things you should be thinking about when you're talking to an estate planning attorney like me, or you're ready to, do your estate plan. Okay. So avoiding probate. So probate is the court process. I don't know if this is elementary for you guys, if you know about this or not, but we're just going to go over it for the sake of completion. So probate is where your family ends up in court and has to ask a judge, because you haven't made a will or a trust, how they get access to your stuff. Okay. So the court system is protecting you, so people just don't come grab your things if you were to pass away. But it also is a painful process for the family sometimes, because they have to go to court, hire an attorney like me to get access to your things. You can avoid this by creating a trust or a will and having a plan in place. Okay. Now, people are confused about a will. So what a will is a will is a document that is presented to a judge when you pass that says this is who gets what, when, and where. Your family with your will is still in court, but it's telling a judge what to do. If you don't have a will, the judge is going to decide what to do. A trust is another document which you would have alongside a will that tells basically the government that you don't need to go to court, you don't have to go to probate, I've already planned. So the government is incentivized individuals to plan ahead of time in terms of estate planning so that they don't have to go to court when they pass away or become incapacitated. So if you take advantage of this, you can really do a lot with all of your assets and make sure that your family is taken care of or any of the wishes that you have, if that makes sense. And I'm trying to, hopefully the whole screen's here. So just so you know, in California, if your family goes to probate, it's actually more expensive than if you would have done your planning ahead of time. So there's statutory fees that are set by law that the attorney and the executor of the estate will receive if they have to take your estate to court. So as you can see, it's 4% on the first $100,000 of your estate. And it goes all the way up after that. So the first 1,000, then the next, you know, over 15 million, and it gets pretty significant. So the next thing is maintaining control. If you do estate planning, you can maintain control of your assets in the event that you can't act. So you're putting people in place to make decisions for you based on your health. You're putting people in place to make decisions based on your assets. You're making sure that if you have certain kids that you want to receive things, that you have people in place to act for them, or if they're mature enough to act, they are actually acting and not having to listen to someone else. So that all that depends. But in order to maintain control and not have the government decide what's happening, the estate plan can take care of that. So what I'm going to do really quick, because I kept this on the side here, is I want to go to the end and ask you guys to kind of think about something. So when you do estate plan, we're trying to protect everybody and make sure that you have a plan ahead of time, right? So these are the questions we think about on whether or not you need advanced asset protection planning or an estate plan that's comprehensive for you guys. So if you look at these questions, there's like a tally on the side here. So like, let's just say you have assets titled in your name. Give yourself 10 points, okay? We're gonna title up how many points each. So I would say, yes, I do. So I'm gonna be 10. Age 75 and operating motor vehicles. Nope, that's not me. Net worth above, you know, 2 million in cash. Okay, so I'm at 25 points. So if you go down this list, these are all things that are triggers for an attorney. That means you need a plan, okay? So you rent or lease equipment to others. You have over 500,000 in liquid assets. You have 2 million in liquid assets. You're a director or officer of a closely held corporation. You're a director or officer of a publicly held company. You have income over 250,000 a year. You're a professional developer or business owner. You own, rent, or lease real estate. You have personally guaranteed loans, so you've given people money. Teenagers, domestic staff drive your vehicles. You have a boat, a plane, or a recreation vehicle titled in individual names. So you meaning you own a boat, a plane, or a vehicle in your name alone. You operate a motor vehicle. You're married more than twice, and you employ over 25 people. These are all triggers for someone that needs an estate plan. So if you can add kind of all where you fall, and I can email this out later, this is what they say. For lawsuit exposure risk analysis, when we talk to you, when we have our initial meeting, or we get further down the line with, you know, your planning, we basically figure out, okay, do you have an average risk lawsuit exposure, above average, but you know, high risk, or if you're over 50 or extreme risk. So if you add up all these things and you hit some of these, you're at risk for liability, right? So when we say maintain control of your assets, we're trying to limit your liability risk so that someone can't come and take them. And you can do that by creating an estate plan. So I hope that gives you guys something to think about there. I'm going to go back up to where I was. So the other reason that what an estate plan does is also helps transfer assets. Okay, so upon death, assets can transfer immediately if you have a trust, right? They don't have to, you know, file paperwork, go to court. It says it in the trust. Oh, this is now the trustee. This is for my kid. This is now my kid's name. It's already laid out. So it's quick transfer, like no delay. If you have to go to probate, it could take up to 2 years. They're getting better after COVID. So it took me, they were on kind of like a 2-year delay, but they're getting faster. So I would say probably a year to 2 years now. And And also, if you've planned ahead, you can transfer things privately, right? It's not a public record. If you haven't planned ahead of time, everything becomes a public record. And if that's important to you, then you need a plan. So trusts aren't public like probate records. They avoid probate court. Everything that we establish, we do with attorneys in probate court now is information someone can look up. So if that's important to you, some people it's not, but some people it is. So I bring it up. You can maintain your privacy with regards to your assets if you plan ahead of time and use, estate planning, trusts, and different techniques that we have. When you do a revocable living trust or an irrevocable trust or a family trust, you can avoid also court supervision. You don't have probate referees assigned to your estate trying to figure out the value of everything. That's another thing. And pardon me, I need water. And please let me know if I'm going too fast. Sometimes I talk too fast. The other thing is protection from incapacity. So this happens, people will become incapacitated during their lifetime, whether it's because they lose their memory or they forget things. I'll give you an example. So we had a client whose mother started to not remember everything, and it had onset of dementia pretty quickly, and all of a sudden thought she had a boyfriend online who she kept sending all her money to, like $50,000 here, $10,000 here. And obviously if she knew what was happening, she wouldn't want, she wouldn't want to be acting this way. So she had an estate plan in place where her daughter could step in and say, hey mom, I need to start paying your bills. We can't be sending money to these people. And her mom kind of didn't know what she was doing. So that's another way to protect yourself if something like dementia comes in and maybe your elderly parents, or as you get older, you don't quite know what you're doing. You have someone that you trust in charge of your assets to pay your bills. That will help with that. So we plan that ahead of time. The other reason is to avoid family disputes. So if you lay out your wishes ahead of time, no kids are going to be fighting. We always hear with celebrities in the news that everyone's fighting over the assets or random tangible items like, paintings or artwork. And so that can be taken care of ahead of time. The next big thing is tax planning. So tax planning is an issue in two forms that we think about when you guys come to see us. We think about if you're going to pass real estate on to your kids, are they going to keep the same property tax as you? So depending on what state you are, that's different for every state. Let's use California since I'm here. So in California, your kids can only inherit property from you if they and keep your property tax basis if they actually move into the house and you've had the house for at least a year. On every other property you give them, they're going to have to pay an increase in property tax. The property will be reassessed and they'll pay the new property tax. A lot of kids or kids inheriting their parents' real estate can't necessarily afford the increase in the property tax. So if you plan ahead of time, we can anticipate this and make sure that if you wouldn't want them to sell the real estate, that there's a way for them to pay for the increase in property tax. The next thing that we think about is the estate. This is a federal, and this is a law in California for anyone who is domiciled here on the law, on the property tax here, but it's going to change per state. This law will cover every state. This is a federal law. So this is the estate tax exemption. So right now you can give away up to, let's just round off $13 million per person, per husband and wife. So husband 13 million can give away, wife can give away 13 million. So it's $26 million of your estate can be gifted to the next generation without them paying the federal estate tax. Okay. Everything over 26 million from now until December 2025 is going to be taxed at 40%. It's a federal tax. It happens. It's not state. This is not a state law. This is federal. So everything over that will be taxed. If you plan ahead of time, you can lessen the estate tax. This diagram shows you basically kind of how it's changed over the years. This law where you can give away up to 13 million per person, husband and wife, is sunsetting at the end of 2026. Sorry, end of 2025. So we have until about January, December, the last day in December 2025 to move assets to the next generation at that level. After that, it's dropping down to 5 million per husband and wife. So 10 million. Okay. Okay. And then you're gifting, obviously, if we're looking at taxes, you can gift money and that changes based on the legislature. Right now, there's no proposal to change that. Another thing is like peace of mind, right? So if you have everything set up, a lot of people don't like to think about dying or getting incapacitated or bad things happening. But if you have everything set up, at least you have peace of mind that things are going to go the way you want it. And you still are maintaining control in a sense because you put down your wishes and it's in place and you're delivering, what you want to who you want, when you want, and not letting the government do that for you. If I can, so now I want to talk about setting up a trust. So there's lots of different trusts, right? And there's 3 levels of estate planning, which a lot of attorneys like to talk about. The first level is a revocable living trust, which is what most people have. That trust allows you to avoid probate. There's no liability protection in a revocable living trust, but it does allow you to say, this is what's happening if something happens to me and I don't want my family going to probate. This is who gets what, when, and where. Okay. So that's the most common. Everyone has one. And even if you do an asset protection trust or an irrevocable trust, you're still going to have the revocable. Along with that, like first level, you also have a will. And the will is a document that just says that if anything is titled in your name alone when you die, I either have a trust and I want it to go to my trust, or I want it to go to these people. So that goes along with the revocable living trust. And when you do that first level of planning, which if some of you have done this, you probably have them, you'll have a DPA for your assets, which is a durable power of attorney. And then you'll have a healthcare directive, which states who makes healthcare decisions for you. So the will, the healthcare directive, the durable power of attorney, and your revocable living trust are like level 1 of estate planning, the first stage. After that, you can start doing planning based on your assets and how you want them transferred. If there's issues, if there's a liability issue with the assets, if you're worried about creditors, if you're worried about lawsuits, if you're worried about nursing homes, if you're worried that you have a child that will receive the money too young and you don't know how they're going to use it. And then also tax issues, that comes next. So after the basic planning, the next level is there's 100 options to go. It's all about strategy and all about planning with your lawyer, your financial advisor, your accountant, and your family. So I'm going to try to play a video from one of my colleagues who works on these trusts. And this is one of his designs. And hopefully you guys can hear it. So let me stop share. Let me share again. And let's see if I do have this going. Okay. Let's see. Let me hear it.
We've all heard the expression, have your cake and eat it too. Well, what if you could do that when planning your estate? What if you could take advantage of the generous lifetime gift tax exemption laws by placing your property into a type of dynasty trust so the asset's value grows free of death taxes for multiple generations? Yet, if you later want or need all or part of the gift, it's yours. Meet the Heirs Trust. With traditional gift planning, once the gift is made, it cannot be reclaimed. Yet, if the Great Recession of 2008 taught us anything, it's that you can never be certain you have enough money. Let's say you have an estate with assets you expect to significantly appreciate during your lifetime and would like to take advantage of the current $12.9 million gift tax exemption. But if your financial circumstances change, how to access the gifted assets? Here's how the Heirs Trust works. You establish the trust in one of the qualifying states like Nevada or Alaska and use all or part of your $12.9 million gift exemption to fund the trust to avoid any gift taxes. Assume a gift of $10 million that earns an average of 6% per year will appreciate to over $60 million after 30 years. Wanting to take advantage of the generously large gift tax exemption, your tax advisor recommends that you make a gift of $10 million to a dynasty trust. You like the idea, but if later you want some of the gifted assets back, you want the ability to potentially reclaim part of the gift. How do you access assets already transferred to the Heirs Trust? Under the terms of the trust, your precatory request of the trustee for some of the assets you previously gave to the Heirs Trust, say $1 million of the total $10 million given to the Heirs Trust, and the assets are set aside in the subtrust and distributed for your benefit. How much will you save in death taxes? It depends on how large the gift grows in value and the then estate tax rate. The current estate tax rate is 40%. If your $10 million gift grows to over $60 million, your death tax savings are more than $24 million. If the assets grow at 10%, your tax savings will be almost $48 million. Worried about lawsuits? How about your child's divorcing spouse laying claim to the assets of the trust? What about bankruptcy or civil lawsuits? With the HISA trust, these are not problems because your children's and grandchildren's creditors are not allowed to touch the trust's assets. What if your estate exceeds $12.9 million? Again, not a problem. The HISA trust may be used to freeze your estate. You can sell some or all of your remaining assets to the trust for an IOU. While your IOU receives a modest interest rate required by government regulations, the assets you sold to the HISA trust appreciate in the trust with no death taxes for up to 360 years. Skeptical? Take a look at IRS Private Letter Ruling 200944002 and related rulings authorizing this kind of planning. While the PLR may only be relied upon by the taxpayer who requested it, you can see how the IRS treats this kind of planning transaction. The bottom line, you have a choice. Use a conventional irrevocable dynasty trust and lose the power to reclaim the gifted assets, or upgrade your trust to the HISA trust and the tremendous flexibility, asset protection, and estate freeze capability of this more robust trust vehicle. That's why we named it the HISA trust. You really can have your cake and eat it too.
Okay, let me go back to my presentation. Okay, so that was an example of second stage as like estate planning. So the first stage is you have to do the revocable living trust, the will, your power of attorney, and your healthcare directive. That example of that trust is an example of an irrevocable trust that you can use to transfer assets to the next generation and protect them. So in order to do advanced planning, we would use these different techniques. That's just one. There's 100 different options. That is one attorney that works at my office and consults on his trust that he has actually trademarked and his strategies. And so it just, everyone's different, and you have to talk to your team and the attorney that you're working with, or myself, and we will come up with the best solution. But I thought that video was very clever and, you know, kind of shows what's happening when it's kind of hard concepts to grasp. When you set up a trust, the estate planning attorney, like myself, will help you move things into the trust. So you just don't you don't do the document and then kind of get thrown to the wolves, as they say. You actually have to move assets into the trust once you create it. And so that's another discussion we would have if you guys were going to do your estate plan, or if you've done them in the past, you probably have, are familiar with this, but we would talk about how you actually get the assets in the trust and what assets you want in the trust. And also what happens when the asset gets into the trust. The one example, which is the biggest one, is people's homes. So transferring your home into a trust, you're going from you as an individual, if you own it, to the trust, and you as the trustee of the trust, or the creator of the trust, or the beneficiary of the trust, right? So sometimes you can be all three of those things. But we'll move it in, we'll deed it into the trust with a deed, and that's an important asset to protect. And so we would help you with that. The next part is, if you're charitably minded, you can also do charitable trusts. So it can go in so many different directions after we've finished the first planning, and then we look at your whole exposure of liability and taxes. So I'm going to, how am I doing on time? I have time to do one more, I think, video. I want to show you one more. Let me try to find it. It was not working when I tried to link
Drinking
it.
warm water before
No.
bed.
Let's skip that. Didn't go direct. So how do I skip the ad? Let me stop share and then go again. Hopefully I can remove the ad, guys. Sorry. Bear with me.
balances blood sugar levels, and reverses type 2. Thousands of people.
This is again the trust that was
Unless
signed
your
by
state has an unlimited
McNulty.
homestead exemption, the equity in your home is at risk of loss to future lawsuit creditors and predators. As part of the estate planning process, we employ strategies to help our clients protect their legacies, including their personal residences. How? By transferring your personal residence or vacation home to the HELP Trust. The HELP Trust is an irrevocable trust established for the benefit of your kids and grandkids. You then rent the property at market value, thus becoming a tenant instead of an owner. Start by conveying the residence or vacation home to a single member LLC, taxed as a disregarded entity. The transfer to the LLC should not cause a reassessment of value for real estate property tax purposes. Then form the HELP Trust in a state like Nevada, South Dakota, or Alaska. Transfer the LLC interest to the HELP Trust using the available unused gift tax exemption, $12.06 million per spouse in 2022, to avoid paying gift tax. The gift of the LLC should not cause a reassessment of value for real estate property tax purposes. Enter into a rental agreement with the LLC at fair market value rent for the occupancy of the residence. If sued and when the plaintiff learns you no longer own your residence or vacation home, the plaintiff should become less motivated to continue with the lawsuit because they will not be able to levy against the real estate in the absence of a fraudulent transfer. As a tenant, the equity is no longer open to attack, and depending on the type of HELP Trust you select, the future value of your real estate may continue to be used without causing it to be included in the gross estate. The rental payments to the LLC will effectively fund the HELP Trust with additional cash without being deemed a taxable gift. And because the HELP Trust is taxed as a disregarded entity, that rental income will not be subject to income tax. Each state has its own rules regarding property taxes, documentary transfer stamp taxes, and other issues that require a thorough evaluation. But for most people, this planning will provide the peace of mind that if something goes wrong, your residence has been removed from harm's way.
Okay, so I think I'm gonna open it up to questions if we have time, but I want to end with, if you think about your estate plan, there's three things when you come to an attorney, we're worried about: probate, liability issues, and then tax issues. And those three issues we're always thinking about everything with regards to that. Then the next thing we're worried about is, are you in the stages of your estate planning? So have you done your will, your revocable living trust, your durable power of attorney for your assets, your advanced healthcare directive? Has that completed? So that needs to happen first. Then after that, we start talking about liability issues and then the tax issues. And I try to give you a little bit of a glimpse of kind of what that looks like if you kind of got a strategic financial and estate plan together with those examples of asset protection trusts, which I just showed you in those videos. And again, there's multiple ways to do it, but those were just two examples. And we went over this very quickly. It's a very in-depth topic, but I was trying to give everybody on this Zoom a general idea of what an estate planning attorney does that's only focused on estate and financial planning. So that is it. Do we have any questions?
I saw there are two questions
Oh.
in the chat box. So one of the question was from Albert. He was asking if we could share the slides after the webinar.
Yeah. Yes, I can.
Yeah. And then the next one is Jing, does property tax uncapped transferring from individual to trust?
Oh, let me look at that question. Let me see if I can find the chat. Hold on.
Can
There it is.
you?
Okay. So the property tax transfer, so it's going to depend on where we are. So I can speak to California. When we transfer a property from an individual, so I own a house in Meghan McNulty's name and I'm transferring it to the Meghan McNulty Trust. I'm going from me to my trust since I am the original owner and now I'm the creator of the trust. I will not have a property tax increase. The property will not be reassessed. So in California, the California tax, you know, the property tax assessor's office will not say, oh, when they see the deed get filed with the county, will not say, oh, I'm going to reassess it because it's a new owner. They're going to say, oh, it was Meghan and now Meghan McNulty's trust. So same owner, no big deal. If it went from me to someone else, then it would be reassessed. I hope that helps. That
So what if you create a trust with your husband and you transferred the property into the trust you both created? Is that going to uncap?
So you own, what state are you in?
Michigan.
You're in Michigan. Okay. So we would have to check with the Michigan rules, but basically normally not, right? So if you own property and you move it into a trust that you have with your husband, you're still the same owner and you're still going to be the owner in the trust, right?
Uh-huh.
So it shouldn't. Now, if you are moving it into a trust where now you're adding a bunch of owners to that while you're living, it could create a reassessment.
Okay.
A way around that is your trust with your husband. You could have that, and then if I think this is what you're asking me, and then it would be a strategy plan, right? You would move it from your name alone to your trust, so we wouldn't have a tax issue. And then you may have to assign that trust to your trust with your husband in case you were to pass away or become incapacitated and you're worried about a probate issue in Michigan, if that helps.
Okay.
Even in the state of California, there's now a new rule in Los Angeles that they created where they have their own set of rules for transferring property to LLCs, to trusts, to different people, because they have a new tax that's supposed to go to help the homeless. So we have to, you know, every county, we have to take into consideration the property tax issue, which when you would sit down with me or another attorney, they would go over with you.
Okay. But you guys will come up with the best strategy to not uncap the property tax.
Yes, correct. So we're worried about
Okay.
the property tax and then your estate tax exemption, giving away money. Correct.
Okay.
Yep.
And if the county and you know, doing something wrong, like they did uncap it, am I hiring you to fight them, or what should I do in this situation just in case it happens? Like they shouldn't.
If they shouldn't do it,
Uh-huh.
so your county assessor office, we would file certain paperwork to show them. They might ask to see the trust to see that you're the same owner, and then that would avoid them. It does happen though. Yes, you're correct. They could say incorrectly decide to reassess the value. I think, did I answer your question?
Yes. So
Okay.
when that happens, what can I do?
If they reassess the value of your house or property when you move it into a trust, you have to respond to the county assessor's office or whoever it is in your specific, wherever the property is located, that I did not create a taxable event by moving this. I'm just moving it into a trust that I created and I'm still the owner.
Okay. So I will need to hire a lawyer eventually.
Yeah, I would have to give you the correct paperwork if you're working with me or the attorney you're working with to make sure that they didn't reassess the property.
Okay.
Okay. Okay. Oh, do we do business in Florida? Yes, we do. When is the latest to do the lifetime gift exemption if anyone who needs to do a tax plan? Okay. Okay, so the lifetime, let me go over this again. So the lifetime gift exemption is right now, the law is that everyone can give away, I'm rounding, it's a little bit higher because of inflation, around $13 million, okay? So if you're married, your husband can give 13 and the wife can give 13. So that's 26 million. This is gonna drop to 5 million each at the end of in December 2025. So we have about 12 months. So if you want to take advantage of this estate tax exemption, you have to do it within the next 12 months. Right now, both Democrats and Republicans have not presented legislation to change this law. It is going to, the the law is going to sunset back down to 5 million, maybe a little bit higher. It might be around 6 million. But as the economy changes, that number will fluctuate every year. So in January 2026, everyone will be allowed to give away 6 million instead of the 13 million. So I don't see it going, there's nothing presented that it's going to go back up to $13 million. So a lot of people are taking advantage of the fact that they can transfer that amount of money to the next generation now. Okay. Okay, so can we use the trust fund to invest in new real estate projects? You can definitely buy real estate with your trust, just like with the LLC. Capital gain tax issues. That would depend. We'd have to look at that. But yes, you can buy real estate with the trust. Any more?
Or anyone want to turn on your mic and then you can ask the question. Okay.
Yeah, so I guess if I was going to say if there's no other questions, like the biggest thing to think about is, do you have a plan in place so your family doesn't have to go to probate? Do you have any liability issues? Are you worried about creditors or lawsuits, etc.? And then the next issue is, are you worried about taxes? And then making sure that you deliver your assets to the next generation where it's protected and you're taking advantage of the laws in place that are there to encourage you to plan ahead of time. So the US government is encouraging people to plan ahead of time. So they're saying, if you gift this money in an irrevocable trust to the next generation and you plan ahead of time, we're not going to tax it. If you don't do any planning, they're going to tax it at 40%. How much asset worth to get a dynasty trust? I'm not quite sure what that means. I think, do you mean how much can you put in there? You can start at any time, actually. So doesn't matter anything. So in California, anything over $180,000 will go to probate. So you could start anything. If you're if you're worth over $180,000 in California, you should have a trust. After that, if you have at least anything over, I would say $13 million, you should have a dynasty trust at this point. Now, if you ask me that in if you ask me that in December 2025, I'm going to say if you have assets over 5 million, you should have a dynasty trust. Just because I want people to take advantage of the estate tax exemption. I hope that makes sense.
So what's the difference between a living trust and a dynasty trust?
That's a really good question. So a living trust, even if you had a dynasty trust or an irrevocable trust, you would have to have the revocable living trust. And what the revocable living trust is it's a wagon that helps tell the court that, hey, I've done planning. I'm simplifying this in general terms. It's saying to the judge, I've done planning. My family doesn't need to come see you. These are my trustees, and I want this and this to happen. And it helps avoid probate. So it's kind of like the first level of estate planning. So if you don't want to put an asset into an irrevocable trust where there's a lot of rules about it and you have a certain trustee managing it and you have lots of documentation, and you don't want to put an asset in there, you might keep an asset in your revocable trust because you have access during your lifetime to move it in and out when you want. You have full control of it. It's under your social security number, so there's no tax return on it. It's literally just a vehicle for you to put stuff in. Think of it as like a wagon for you to put all your stuff in, and you can take things in and out as you choose. With the dynasty trust or the irrevocable trust, you're going to have your own tax ID number on that. So it's going to act like another person, right? Its own entity, like a business or a person. So you'll have to file a tax return on it. There'll be rules around when you move things in and out. And it's not a big deal. You can, but like there's rules, right? So there's more restrictions on it because it's protected. It's its own person or entity. So no matter what, you'll always have that revocable living trust first. So that's for your everyday stuff, guardianship for kids, you know, things that you don't want to put in the irrevocable trust.
Okay.
Actually, there was, I'm sorry. Go ahead.
You always have both. Okay.
So actually earlier there was somebody asking about, okay, if I move all my asset to the irrevocable trust, for example, I appoint my son to be the trustee, right? And if I move everything to this irrevocable trust, and then my son she was talking about some like really weird situation, just what happen if my son doesn't want to give me any money after that? What can I do?
Right. So in your trust, depending on how you design them, you can say, well, if my trustee doesn't do what my wish is, I can fire them and hire another trustee. So if your son is not listening and is not doing his job, how you wrote it down, you can fire him and hire somebody else.
Okay. Okay.
That's important. That's a good point.
Yeah. Any more questions?
I have a question about if you have a lot of property right now, like have the rental properties, all those properties I put some in LLC, but some still under my personal, like a personal property. And in the future, I just wonder how much is you have to put like in LLC and then transfer to under like a irrevocable family trust. Yeah.
Right.
What is the best, plan for, in the future?
Okay. So if you have property and it's in your personal name alone, it's in your name, right?
Yes.
Okay. So when you talk to an attorney, we're gonna run through three things. We're gonna go, A, we want it out of your name, because that means it's going to probate. So we don't want your family ever in court if something happens to you. So it either needs to get moved to a revocable living trust, that's the minimum, or it needs to get moved to an LLC, or it needs to get moved to an irrevocable trust. Now, the fourth option is you can move it to an LLC, that it needs to be assigned to your revocable or irrevocable, depending on what you want it to do with it. So let's go through the three things. So probate, we got to move it out of your name, whether it's one of those entities. Liability issue, if you want to take care of liability issue, you want it in an LLC, because if something happens on that property and you get sued, they're only going to sue the LLC. They could try everything else, but technically they're only going to go after the LLC. So we're going to look at liability. So should it be an LLC or should it be an irrevocable trust? Next, we're going to look at a tax issue. How do we avoid your kids, if that's a concern, paying the estate tax on that property if they inherit it when you pass away? We solve that problem with the trust. Now, if you're not worried about your kids inheriting it, then we solve that problem with the revocable trust. So the one that's revocable, the living trust. So if you're not worried about that, then we would want it to either be in the living trust name or the LLC, which the property is held in, assigned to the revocable living trust.
I see. Thank you.
So then we run through, that runs through all three.
I see. Thanks. Snowy， 我们今天的讲座会有 refund 吗？
Yes.
Oh,
Yes.
太好了。
There's a recording.
Oh,
Yeah,
太
I
好了。
know you were late. So
maybe
I'll send out the recording.
I think it's very, very helpful. And also, I think you need to have more people to have this kind of a seminar in the future.
Right. Yeah.
It's very, very
I
valuable.
know.
Yeah.
Some people didn't realize how important it is.
Oh, it's very important. And
right.
also
It is very
it's
important.
have very limited time now. We have to do it.
Yeah.
Exactly.
Yeah.
Exactly.
I could I try to cover a lot of topics and simplify it, but this actually is like a 4-point presentation broken
Sure.
down. So this was I tried my best to be as general as possible so I could get through all the points, but I could break it down if you needed me to.
Sure. I mean, even we can like schedule another time to do another more, just, yeah, if it's more helpful, right? Yeah, if nobody has any other questions, we'll call it for the night. Or if you have any other questions, it's time to ask Meghan. Okay, if nobody has any questions, we'll
I
just
have
say-
one
Oh,
more question.
sure.
So like modern family, you as a LP, that kind of situation, what you should do, you still need to put the asset in the trust.
So you said a limited partnership?
Yeah.
Okay.
Yeah.
Yeah, so when that situation, that's great. The limited partnership's wonderful. But for each person that's a part of the limited partnership, you would want to have your own individual estate plan. So let's say my family has the McNulty limited partnership and I'm part of that. So I would have the Meghan McNulty estate plan and I would want to assign my interest in the limited partnership to my trust. So that if something happened to me, my family would know that I have an interest in the limited partnership and that belongs to my trust and they should receive that. Now, that normally works, but if there's an agreement in the limited partnership that says between whoever you have that with, that says that, oh, if something were to happen to you, your family doesn't get anything, then, we wouldn't have to assign it to the trust. But normally that's not the case. Normally the case is you have an interest in the limited partnership and that interest you have as an individual should be transferred to your estate
Trust,
or your
right?
trust.
Yeah. I mean,
So you
Sorry.
purchase under your individual name first, then you transfer to your trust.
Yeah.
So
Yeah,
this is
correct.
kind of need to do pretty often since I feel like a LP normally like few years already probably done with it, right? Done with one project, then you just need to do it again.
Yes, you would constantly update your individual estate plan with whatever business assets you have. So I have my own living trust, right? It's Meghan's living trust, but I also have an interest in a law firm. That my interest in my law firm is assigned to my trust. In the event that something happened to me, my loved ones would be able to get access to my interest. Now, my partners don't want to do business with my sisters or my nieces and nephews because I don't have kids. So, they don't want to do that. So they're going to buy my law firm will pay out my family for my interest in my law firm. But that would never have happened without a court if I don't have it assigned to my trust. We're avoiding court. So all these assignments to the trust, make sure it's an easy transfer to the family if something happens to you. Did that make sense? So any business interest you have, whether it's a partnership, a real estate situation, an LLC, a corporation, it's always assigned to your revocable living trust so that your family, if something happens to you, can get access. If you don't do that, it's not the end of the world, but that means you're going to probate court. So everyone has to go to court to get access. But if you plan ahead of time, that does not happen.
Okay.
Yeah, that was a good question, Yan.
Yeah.
Because we like normally we have to do one or two or a few each year for some of our
Yep.
LP investors. Yeah.
So it'll be very simple. It's like once you create your estate plan, you'll have a document every time you do that just assigns it to your trust. That's just, and you write it down, you write it out, you sign that you're doing that and you notarize it. It's a private document. It doesn't interfere with business. They don't need to know about it unless you want them to, or unless it says in the agreement that they need to know if you have a trust.
So every time you do that, you need to find your lawyer to help you, right?
Yes, you should, or your accountant might be able to help you do it. So once you've done your estate plan with your lawyer, the accountant could help you do the assignments. It's a notarized document, so either a lawyer or an accountant.
Okay.
Yeah. I would recommend talking to the lawyer though, obviously, but
And also normally if already have a living trust in the future, like you say, in the future have things are gonna change, move stuff in, move stuff out, I still can find a lawyer or find a accountant. If so I should stay with the same lawyer or just the the original lawyer, or it doesn't matter.
it doesn't matter.
Afterward.
You can trusts are like driver's license, so you can you can move them around, right? So you don't have to, it's not to that specific attorney, but if you like that attorney, you should, and you're comfortable with them, I would recommend using them again. But if not, you can move around to whoever you want. It doesn't matter. It's not going to affect anything.
Okay, thank you. Because I already have one living trust, but since sometimes the property change or buy a new one, then still need to keep ask my lawyer to add in. But there's one time because I moved to other city, move around, so my original lawyer is in other place, other city. So there's
Okay.
one time I was asking someone if someone just in where I'm in Southern California, so I was thinking if
Oh,
it's
yeah.
convenient for me to ask some local lawyer to do it. They say, oh, then you need to start over, build another living trust. That's why I ask you this question.
No,
Okay.
so let's say you came to me and you said, I want to, update my trust. We would amend your revocable living trust and restate it. So we wouldn't necessarily start over, but we would update it to what you want to do, right? So
Okay, just add in, just add up and update.
yeah, which
Okay.
people do a lot, right? So it depends, as life changes, you're going to constantly restate that revocable living trust.
Yeah.
You don't
Yeah.
have to keep going to the same attorney. You can, but any attorney will be able to amend or restate your trust for you.
Okay. Thank you.
That was a good question.
Thank you.
Yeah. So, okay, anybody else? 5 more minutes. Or we can have one more question if anyone have one. If not, then we can finish it a little bit early.
Well, if no one has a question, I would just say I
Yeah.
would encourage anybody to, did someone? I would encourage you all to do a revocable living trust if you don't have one yet. Everyone should have one. It's important, and it's going to save you in the long run, financially and peace of mind, and with helping the next generation receive your assets, which I'm sure everyone's worked very hard for. So I would just encourage that at the very least, if you haven't done that yet, to contact me or someone like me. And that's it.
I have one last question.
Sure.
This is Albert. Besides today's webinar, any other educational
Event.
information or site or whatever that recommended to look through?
Yes. How about I send over the slides and some recommended reading that I can recommend to you?
Yeah, some reads. Yeah.
Perfect.
Yeah. Awesome. Cool. Thank you, Megan, for all the useful information tonight. I think a lot of people probably could use a lot of your information for their asset and for their future, for their kids too. So thank you again.
Thank you.
Thank you everybody for coming, joining us tonight.
Nice to meet you all.
Okay, yeah. All right then, everybody.
Thank
Good
you.
night.
Thank you,
Thank
Megan.
you.
Thank you,
Thank you.
Snowy.
Thank you.
Thank you. Great
Bye.
job. Thanks.
Bye.
Bye. Have
Bye.
a great weekend.
You too. Bye.
Bye. Thank you.